A federal Capital Territory High Court has granted former Attorney General Abubakar Malami, his wife and son bail to the tune of 500 million naira each in a money laundering case. Now, this is not just a legal formality. It raises the question that can Nigeria's justice system hold its own most powerful to account without fear or favor? Those are the questions. Now, to give us, kind of like on-the-ground insight into the proceedings and what the bail decision means, our correspondent followed developments in court. She spoke with lawyers, observers, and also bystanders to bring the human angle behind the headlines. Now, here is our special report by Joshua Imarayi, News Central Correspondent.
The courtroom of Justice Emeka Nwite at the Federal High Court in Abuja was filled to capacity as former Minister of Justice and Attorney General of the Federation Abubakar Malami, his son Abdulaziz Malami, and his wife Asapi Bashir returned to court for the hearing of their former bail applications. Supporters and associates of the first defendants, Malami, were also present in court. At the commencement of proceedings, counsel to the defendant and senior advocate of Nigeria, Paul Daudu, urged the court to grant his clients bail on self-recognizance and other liberal terms. Daudu argued that the offenses are not capital in nature, bailable, and that the defendants are presumed innocent until proven guilty by a court of competent jurisdiction.
The prosecution on their own part, rather than proceed with the matter, knowing fully well that they do not have any right of reply, insisted that they needed time and they needed an adjournment for them to respond to what we had found. But taking into consideration the nature of the application, which is an application which is strictly a discretionary one, and based on what we had already earlier filed before the court, we drew our further affidavit and proceeded to take the application.
Counsel to the Economic and Financial Crimes Commission, Ekele Iheanacho, opposed the bail applications, arguing that the defendant posed a flight risk. He further told the court that granting bail could lead to interference with witnesses or tampering with evidence.
After hearing argument from the defense and the prosecution counsel, Justice Emeka Nwite has adjourned to the 7th of January to rule on the bail application filed by the defendants. As a result, the former Minister of Justice and Attorney General of the Federation, Abubakar Malami, his wife and his son will remain in the custody of the Kuje Correctional Facility, pending when the ruling is delivered. In Abuja, for News Central, I am Joshua Imarayi.
Joshua Imarayi, who filed in that report, very stellar report, by the way. He'll be joining us in just about a bit, if I'm not mistaken. Joshua is with us already. Joshua, good morning to you. Grand. Good morning, Joshua. Joshua, tell you what we're going to do. We're going to go on a short break, fix your audio, and then when we get back, we'll start this conversation.
Welcome back, and this is still our first big report, and we have our correspondent Joshua Imarayi on standby to tell us about the atmosphere in court concerning the Malami case. Good morning, Joshua. Can you give us an update of what happened at the court?
Well, good morning to you, Queen, and good morning to you, Mazino. That particular day, the court was supposed to rule on the bail application filed by Malami, his wife, and his son, his wife, and his Asabi, his wife, Abdulaziz Malami, all in a trial and are currently accused by the EFCC of conniving to launder to the tune of 8.7 million naira. So that day was supposed to be the ruling of the bail application, and the court was absolutely calm, the type of calm that you experience before a major ruling or major decision is made. That type of calm was what you experienced in court that morning. Malami was in court, same as his son, his wife. But for supporters of Malami, what we witnessed is that the court was some sort of small justice. Emeka Nwite's court is 4 years, and it was the beginning of the year, yes, and the courthouse was not really full. But we noticed that some of the supporters of Malami were not granted entry into the courthouse. There was a point where the EFCC had to cordon them from the courthouse, and they had to walk miles away before they could access the courthouse itself. So that's the kind of calm that you see, and that is the kind of arrangement, the security protocol that the EFCC put in place before the ruling. But when it came to the ruling, the judge gave them bail to the tune of 500 million naira each. So for the three of them, we are seeing the summation of 1.5 billion naira, and that each of the defendant has to have a shorty, two shorty each, who has landed properties in areas like Warimpa, Asokoro, and Maitama, eyebrow areas, if I must say. And so, of course, you know that these individuals have perfected their bail and they are with their families as we speak. So that is what transpired in court. And of course, we saw that some supporters from social media across different lines, and some people who were not, were some sort of disgruntled at the ruling, they began voicing out opinions, several opinions. If you go through social media, mainstream media, several opinions on the bail give granted to Malami. Queen.
Joshua, the court had granted bail, like you said, of 500 million naira each, but there were other conditions as well. I'm wondering what these other conditions were. And then the EFCC had concerns. They had concerns that the suspects might tamper with witness or even jump bail. What response did the court give for the EFCC concerns?
So I'm going to start with the allegations that the EFCC made concerning the defendant, saying that they were going to tamper with witnesses or perhaps jump bail. One of the arguments that the defense counsel made was that these statements were blanketed statements that were not having particulars. When I mean particulars, evidence pointing, I believe evidence before the court pointing that this is what they were going to do and this is how they were going to do it. This is who they are going in contact with. So the court stated that these claims were not enough to deny them bail. Because why? The primary concern of the judge is they are making themselves available for trial. And they fulfill all the other conditions to make themselves available to trial. Because before now, the EFCC had granted them administrative bail. And when granting administrative bail, you tender your travel documents, sometimes shorties too, and sometimes properties, others. But what the court is saying that the EFCC granted them bail. Yes, they did not abscond. And for a fact, their travel documents are with the EFCC. So it is quite unfounding to say that they were going to abscond. And for them tampering with evidence, mainly altering investigations and what have you, the court said that the EFCC did not bring forth particulars to the point that this is what is going to happen. Because, of course, you know that the court is a court of records. And court of records deal with facts. And what the court said that the EFCC did not prove beyond reasonable fact that these persons were going to do what they were going to do for the court to deny them bail. And the court refused the EFCC's objection and granted them bail.
While you're talking about evidence, did the court provide any evidence linking the former AGF or linking properties or transactions directly to the period while he was in office as AGF?
Well, for the trial itself, we've not gone to that phase where evidences will now be flying around like, of course, level backed. No, we've not gotten to that point. What we are seeing is bail applications and bail ruling. When a defendant is being arraigned before a court, what happens first is the person takes a plea and the person is remanded in custody. The next move is to move for bail application orally or formally. They moved orally and they were denied, and they also moved formally and they were granted now. But we are seeing that come 17 February, the case will commence in full motion. Of course, we'll be seeing them bringing forth evidence, witnesses, exhibit, and what have you. That is when we are going to see what the EFCC has to prove the allegations they have against the Malamis.
So, Joshua, I think Mazino will be wondering, like, Queen and her numbers. He's allegedly accused for 8.7 billion naira, and then the bail for the three of them is 1.5 billion naira. So it's a bit confusing as to how they got to that amount for bail. So aside that is one. Did you detect any tension or disagreement among the legal observers about this bail decision and the amount?
Well, there was no tension particularly for the bail amount. But one thing we understand is that the defense counsel told the court to grant the defendant bail in every legal term possible. And it is a sole responsibility of the court to ensure that the defendant gets that right to fair hearing. And one of the ways the court will ensure that the defendant has a right to fair hearing is by giving lenient bail conditions. The moment a court starts giving stringent bail conditions, the defendant might have it a little bit difficult to avail himself of trial or even not to jump bail. So once the court gives you some sort of leniency in that, it gives the defendant the morale to stand in court for trial. And of course, you know that to prove a case is the prosecution's own sole responsibility. What you have against any defendant is the sole responsibility of whoever is prosecuting to prove it. So the court is going to give that sort of standing to the defendant, and maybe the responsibility of proving case would be given to the prosecution. So that is why that leniency came about. But in terms of reactions to the bail conditions, we weren't experiencing any in the court house. But what we saw was that reactions poured in across social media lines. That was what we confirmed, Quay.
You mentioned the reactions poured in, on social media and all that. Can you tell us some of the reactions, from Nigerians?
One particular reaction that I'm seeing is that from the northern extraction, they seem to be sympathetic to the former AGF. They are saying that this is just another political victimization, saying that the former AGF dared to renege against this current administration, that he is one of the founders of the ADC, allegedly one of the founders of the ADC, and that because he has shown strong interest in being opposition in the past to the same APC he was once a member of, they are saying that this is just another attempt at political victimization. While some from the southern extraction, particularly the same APC members, are saying that let Malami come to court and maybe answer to the allegations laid against him by the EFCC. If the court finds him not guilty, it's fine. But if the court finds him guilty, then he has to pay the price and bear the consequences. So we are expecting that the court will do justice in its wisdom, maybe to convict or to discharge. Queen.
Imarayi, that's a very interesting submission there, that last one regarding the conspiracy about being the founding member of the ADC. I never saw that one coming. However, that in mind, how do you think this changes public perception when it comes to the judiciary? Do you think, or law enforcement, or enforcement actually, do you think that people are much more confident in the institutions that we have now, seeing them go after individuals that might have embezzled or used public offices unscrupulously? Do you think that Nigerians are confident, or this raises confidence in Nigerians for the system?
In the past, Nigerians have been divided over the responsibility and the mandate of these agencies, particularly the anti-graft agency that those prosecuting the Department of Public Prosecution. Most people say for a fact that the procurement processes of getting their leadership is the main reason why those leadership are some sort of dysfunctional. Because of course, you know that the president is responsible for the appointment of these individuals. And Nigerians seems not to be comfortable with that fact, that the president is going to appoint the head of this agency, who in turn will answer to the office of the president. So there's this debate ongoing. But one thing we saw in this ongoing Malami case is the fact that after giving ruling, that day where the Justice Emeka Nwite of the Federal High Court delivered ruling, Justice Emeka Nwite came out shockingly to say, to give some remarks, and in his words, that he is unapproachable, that his leniency should not be taken for granted, that anyone who approaches him outside the court for any favors, for any arrangements that is relating with the courtroom, will be resisted and dealt with. That is the judge sounding the alarm and reading the riot act to both counsels, litigants, defendants, and like that. Nobody should approach him outside the court. Now he is maintaining the stance. Now, for a judge to come out and say something of such, you will understand that something has gone down beyond closed doors. Some permutations are certainly permitted that made the judge came out to say that nobody should approach him outside the court. So this is one of the concerns Nigerians are raising. And some Nigerians, particularly from several quarters, if I must mention them, Chidi Odikano, is saying that if a judge should come out to say something of such, means that he is being approached, and that the judge should not hesitate to point fingers. Now the question is, will the judge, Revered Honorable Justice Emeka Nwite, point fingers? That's another question for Nancy.
Very, very interesting question. I also have one more thing to talk about here. When it comes to these kinds of cases, we always never hold ourselves accountable as the people, as the citizens. So let me give you an example. Abacha loot. We're still talking about Abacha loot only since forever. In fact, only just last week, they're still talking about repatriating a very huge chunk of it. This is since Jonathan's time, actually. Now we're seeing another case where it's a case of misuse of office or embezzlement of funds. Are Nigerians ever concerned about all of these? Do we ever say, that our money that is being owed or that was taken or stolen, how are we going to get it back? What do Nigerians owe themselves when it comes to repatriation or recollection of funds that have been misused or stolen?
Well, one thing Nigerians should demand most times when they hear of this fund, it's not just hearing, they should demand accountability. Publish figures, where this money is going to. Explain. The government was elected by the same people. The government derives its power from the same people. And it is expected that Nigerians hold the same government accountable by demanding that transparency, accountability should be the order of the day. If such money is repatriated and is brought into the country, details should emerge. The government should not hold back details, because once you hold back details, public officials who might be tempted with a huge sum of money might want to divert some for personal purposes. Well, because it's a huge sum. And most times corruption is giving the avenue to thrive when accountability measures are not put in place to ensure check and balances. So when people are not scrutinized, when those who have unfettered access to these resources are not scrutinized, and mechanisms are not put in place to ensure that corruption does not take place, we begin to experience this. Now, it is the sole responsibility of the court to convict the former AGF if he actually committed a crime. But we must understand that we should not give space for corruption to happen, because corruption will always fight back with the resources garnered from where it was allowed to thrive. Mazino.
Well, thank you so much, Joshua Imarayi, for this report. And of course, the trial has been adjourned to February, so we can't wait to see what your report will be in February. We appreciate you joining us and giving us, the situation report. Thank you, Joshua.